Hi, everyone. Thank you so much for joining us today. We're looking forward to an excellent conversation with Bill. We're just going to wait for a few minutes for additional attendees to join. Thanks for being here. Thank you so much, everyone, for joining us today. We're looking forward to a very exciting and enlightening conversation with Bill Rivers about the new Civil Rights Playbook. We're thrilled to have you here joined with us for this impactful and timely webinar, where we'll explore how evolving civil rights strategies are shaping the fight for justice, equity, and inclusion in the United States and beyond. In a moment, our featured speaker, Bill, will unpack the new Civil Rights Playbook means in practice, from how fundamental rights are being defended in current legal frameworks to why language access and equitable enforcement remain central to achieving true justice and opportunity for all. Today's session is designed not just to inform, but to equip you with insights and tools that can be used in advocacy, legal practice, community organizing, and policy work. Whether you're a civil rights advocate, a professional, a student, or a concerned citizen passionate about equitable access and rights protections, you'll find value in the perspectives and strategies that we'll discuss today. Before we begin, just a few housekeeping notes. This session will include time for Q&A, but please submit your questions in the chat, and we will be pulling them up as they pertain to the questions that we are currently discussing. And then we also encourage you to participate. We really do want to hear from you. We want this to be a dialogue. If you have questions, if you have comments, if you have experiences you want to share, put it in the chat and we'll pop it up on the screen. And hopefully Bill will be able to shine some light on some things for us today. Without further delay, please join me in welcoming Bill Rivers, who will guide us through the new Civil Rights Playbook, key concepts, changes, and challenges that are guiding civil rights work right now. Bill, could you tell us a little bit about yourself before we get started?
Of course, and thank you, Elizabeth, for hosting this, and thank you, Effectiff, for putting this program on. My name is Bill Rivers. I am a lobbyist and consultant in the Washington, D.C. area. I've been involved in language access for more than 25 years as a practitioner, as someone who has worked on needs assessments and developing language access plans and policies for state-level agencies, for state governments, municipal governments, and as a lobbyist in Washington, D.C., supporting language access rights. I do a lot of work with the language industry, the Association of Language Companies. I lobby on behalf of the language industry, but I also work for a number of other clients. My own history, I started my career as a English-Russian interpreter and translator in the late 1980s. I've been an academic. I've been in the private sector. I've worked as a contractor for the intelligence community. I've done a lot of different things, sort of adult ADHD or CEO ADHD, we used to call it. But the last 5 years, I've been running my own company here in the DC area. As a volunteer, I chair two important groups. One is the National Coalition for Language Access, which formed in March of last year, and we're going to probably touch on why that happened, and the Safe AI Task Force, which formed in 2023 after the launch of ChatGPT 3.0, and I'm sure we're going to touch on how AI interacts with language access as well.
Awesome. Thank you so much. We are very excited to have your wealth of knowledge and experience. It sounds like you've worn a lot of hats through the years. So we really appreciate you being here and being willing to share your perspectives and experiences with us. So again, the topic for today is the new Civil Rights Playbook. We're talking about Title VI and changes that have come about. So before we talk about the implications of these changes, Bill, can you explain in plain terms how Title VI enforcement used to work under the disparate impact standard, and what has fundamentally changed with the new requirement to prove an intentional discrimination?
So we have to understand what disparate impact and disparate treatment mean, and they're technical terms or legal terms, but the easiest way to explain it is disparate treatment is deliberate discrimination. It's the sign that says no Irish need apply. It is discrimination based on a protected category: race, national origin, religion. And of course, language is included under national origin thanks to another Supreme Court case, Lau versus Nichols in 1974. So disparate treatment is deliberately targeting a group for discrimination. Disparate impact, instead of saying no Irish need apply, say no redheads. Man, sorry, Bill, we don't hire any redheads. I used to have hair and it used to be red. Or I had more hair and it was more red. Okay, so you're probably going to let some Irish in, and you're probably going to exclude some other people who aren't Irish. That is sometimes deliberate. It is sometimes incidental. It's not necessarily been thought out as a plan to discriminate against particular groups. The way that the Supreme Court has treated disparate impact actually did come out of employment law. A case in 1970 called the Griggs case, where a furniture mill, I believe it was a furniture mill in North Carolina, required a literacy test, an employment test for its workers. And at that time in North Carolina, a very small percentage of African American men had high school diplomas, and so they were failing this test that didn't have anything to do with the work they were doing. And that was seen as discriminatory. Now, disparate treatment is on its face considered intentional because it's right there. You know, whites only water fountains, no Irish need apply, whatever it is. Disparate impact is not considered intentional on its face. It may be intentional, but it's not considered intentional. So that's the first important distinction. Disparate impact still exists in Title VII of the Civil Rights Act, which protects employment because it came out of employment cases. The Civil Rights Division, the Office of Civil Rights of the Department of Justice, had long extended the use of the disparate impact theory to cover Title VI discrimination, which is the discrimination in accommodation to publicly funded programs and facilities, which is where most of the weight of the Civil Rights Act of 1964 comes. In April of this year, the Trump administration promulgated or signed, President Trump signed, they didn't pass anything, signed an Executive Order 14224, that said disparate impact is no longer a thing under Title VI, not Title VII. Disparate impact is no longer a thing, and we're not going to enforce any disparate impact claims. Now, why does that matter for language access? Because the way that most language access language discrimination claims had been enforced by the federal government for the last 25 years at least, since I've been aware of it, and probably before that, was based on disparate impact. The fact that somebody went to a doctor's office or a DMV or a courtroom, a state or county courthouse, and was not provided language assistance, and that wasn't offered, right? And so that was considered disparate impact. It's not deliberate discrimination on its face, but it is discrimination, and it just would discriminate against those who did not speak English well enough to communicate with the government or whatever entity was offering the service, because groups that receive federal funding are also covered under Title VI, and that's no matter how far removed. It might be a county health department that gets money from the State Department of Health, that gets money from the U.S. Department of Health and Human Services. Doesn't matter how far down the chain they are, they're still required to obey Title VI, all of Title VI, not just the language access parts. And it doesn't matter how much money that entity gets, how big a piece of the budget that is. If it's considered $1, then you're covered by Title VI. The idea is that, it's only a small part of our budget, so we don't have as much of a burden. And it also doesn't matter how big the population is. It's another thing people misunderstand. They look at the old 4-factor test and the 5% requirement for translating, 5% guidance for translating, vital documents. Title VI says no one shall be discriminated against. So everyone who speaks another language has language access rights. Now, this is all complex. So executive orders. What's an executive order? An executive order is the president saying to the people in his chain of command, the people who work for the executive branch of the U.S. government, not the legislative branch, that's the Congress and all its agencies, not the judicial branch, not the U.S. courts, but the executive branch, that they are to do something. Executive orders cannot change laws. They cannot change regulations, okay, which is when an agency like the Department of Health and Human Services writes the regulations that implement, say, Section 1557 of the Affordable Care Act, which I'm probably going to touch on. Can't change laws, can't change regulations, can't change court cases, cannot change federal or Supreme Court law, case law, cannot overturn anything that's already part of the law. And so an executive order could be overturned by the next administration, and we'll get to another executive order in just a second. But it's only binding on the executive branch. So to come back to disparate impact, so where does that leave us with the certainty now that if you file a language discrimination claim, you have to file it as a disparate treatment claim. You have to have a higher level of evidence. Now, but there's another court case, and it's so complicated, called the Sandoval case in 2003, 2004, which said that essentially said most language discrimination claims, unless it was overtly disparate treatment, had to be filed as civil rights claims as opposed to taking a disparate treatment claim to court. That, in other words, the Supreme Court said that if you believe you've been discriminated against because of disparate treatment, you first must file a civil rights claim with the Department of Justice or the relevant, in the particular case, it was a DMV case in Alabama with the Department of Transportation at the federal level, or the Department of Justice. But if you have a disparate treatment claim, so someone says, hey, you're from the planet Zod, and we're not providing Zodian, and we don't provide Zodian interpreters because we don't like people from the planet Zod. I'm just making that up, so I don't pick on any actual
of course
language here. If someone actually says that, or if there's a reasonable belief that it is disparate treatment, then you still have the ability to file a civil rights case in federal court. And in fact, there have been a good dozen or so such cases filed over the last 25 years. And in every single case, it has been found, at least at the initial stage, that the judge says, okay, there's a reasonable basis to continue this case. And then I think almost every last one of them ended up getting settled. So it's changed the enforcement mechanism. The reality is very few LEP individuals are going to have the resources to sue the federal government, and or the willingness, especially if they are concerned about their immigration status in this day and age. And it's sort of unequal warfare, as it were, because the federal government has effectively unlimited resources to defend itself. And how much money does Bill Rivers have to pursue that no Irish need apply claim, right?
Right.
So it does change the way that enforcement will look. Now, it doesn't take away the civil right, and that's really important. Now, with Executive Order 14224, Executive Order at 14281, actually 14281 was the 14281 took away Executive Order 13166, and we'll get to that too, I'm sure. Language access is still the law of the land. The enforcement mechanism has changed. You can still file civil rights claims. They won't necessarily be complaints. They won't necessarily be followed up, but it's still worth filing them. Again, bearing in mind that LEP individuals may not want to be exposed on that, and anybody can file a civil rights complaint if they have material knowledge of a violation of civil rights. They can file on someone else's behalf. Sooner or later, the individuals whose rights have been violated or purported to be violated will have to be named in the process. So that's another consideration that I think is a little different than maybe in years past. It's a long answer, but it's not an easy question.
No, it's definitely very multifaceted. There's a lot of back information, a lot of what's happening now impacting the way that things are managed and carried out. And I really appreciate the detailed explanation so that we have a solid foundation to start the rest of the conversation. So my next question, Bill, is can you give one or two concrete examples of language access failures that would have been actionable under the disparate impact, but would now likely not be investigated without proof of intent?
I don't have any specific examples at hand, and that's the interesting thing that we're seeing out in the field, that the decline, for example, in minutes being billed by interpreting companies seems to be more due to the fact that people are avoiding going to the doctor's office, or they've lost their insurance under other laws like the One Big Beautiful Bill Act, than actual failure to provide language access. I have heard anecdotal reports of someone being denied an ASL interpreter because President Trump says we don't have to do that anymore. Incorrect. The ADA still stands and actually has a lot more legal protections than Title VI does for language access in some ways.
Yeah.
However, the National Coalition for Language Access, which is ncfla.org, is collecting examples, and we do have an option where you can upload examples in Spanish or record them in ASL, and we will be looking at those to see if they can be brought to light, because again, we're being very sensitive about people's information. I'm sure people who are in the field working with community-based organizations have plenty of examples, and I can again relate anecdotes that I've heard from my work over the last several years where individuals in state Medicaid offices or municipal area agencies for the aging, there's one of these pretty much in every county in the U.S., have said, oh, we don't have to provide interpreters. They've been wrong, but that's often an individual making a decision at the point of service without really understanding the law and the policies of their own organization. That does happen. To say that there's something systematic happening, I don't think there is right now. I hope I am right. Does it happen on an individual basis where that person at the front desk decides out of whether it's ignorance or malice or whatever, incompetence, not to provide language assistance? Yes, that happens. That does happen. But that has happened for a very long time.
Yeah, definitely. We see that on a daily basis in the language access realm for sure. So under the previous model, data showing disproportionate harm was enough to trigger enforcement. Under the new model, intent must be proven. In practical terms, what would proving intent look like in the language access content specifically?
So this is a uncharted territory, right? Where the data showing disproportionate harm relates most directly to, for example, data showing in our school systems that minority children are detained, suspended, expelled more often, or that minority children are unfairly overdiagnosed as having special needs or are denied access to advanced and accelerated and extracurricular programs. And the Department of Education has said they're not going to do that anymore. The Department of Justice has supported that. You'd have to show that that in the case of an LEP community, that somebody actually decided not to. So there's some evidence that there was a deliberate decision not to provide language access. A decision not to provide language access, I think, would probably suffice as at least a motivation to look at the intent, to investigate the intent. But I'm not a lawyer. I am a linguist. My PhD is in Slavic linguistics, folks. So and my knowledge of the law is limited to a few very narrow topics, right? Like language access. So there are other people who have given this a good deal of thought. Part of the challenge we have, I think, as a field is there are folks who are raring. I know lawyers in the language access and civil rights space who are ready to file suits on disparate treatment, and there are others who don't want to do that at all. And the concern they have is that the decision Lau versus Nichols, decided in 1974 by a unanimous Supreme Court, with a briefing in support of language as a form of national origin discrimination, written by none other than Robert Bork, who was a Solicitor General at the time, a very conservative jurist. But they're concerned that the Supreme Court of 2026 or 27 or whatever might overturn Lau v. Nichols. And so there is a concern about exposing it to judicial review and perhaps even losing the tenuous, what is sometimes thought to be the tenuous link between national origin and language. However, that being said, there are other laws where language access is required. Laws that don't necessarily say that language discrimination is illegal, but that affirmatively require language access, such as Section 2 of the Voting Rights Act, the Individuals with Disabilities Education Act, which requires language access, for example, in the annual, the regular meetings around individualized education plans, IEPs. The Fair Housing Act has requirements. The Affordable Care Act has regulatory requirements, but not legislative requirements. So there are a lot of different places in federal law and regulation where language access is pretty firmly embedded without making the tie to Title VI. And then there's the practical thing about, we still have 70+ million Americans who speak a language other than English at home. Many of them could be LEP depending on the circumstance. At least 25 million Americans who are definitely limited English proficient. Another 10 million or so people who are deaf of hard of hearing of some form who need language and communications access. And in order to provide medical care, in order to provide access to the legal system, it's simply best practice. It's irrespective of whether it's a civil right, which it is, just being able to do your job as a lawyer or a doctor requires, a nurse practitioner requires language access. And that, in fact, has been reinforced by the Joint Commission on Hospital Accreditation in its most recent release of its accreditation standards, moved language and communications access to an issue of patient safety, giving it much more prominence and much more teeth in the accreditation standards. Section 1557 is still the law, the regulation that enacts it, or is still there. So all of this infrastructure for language access, legal infrastructure, most of it's still there. Proving intent, that's, you'd like to think that people aren't, that blatant in their biases to just come out and say, I don't like X group, and so therefore we're not providing interpreters. You're here in America, so you should speak English. We know that happens at an individual level, and it's wrong. When it happens at a healthcare facility, an individual does it, that's often ends up being a disciplinary matter because it's a violation of the healthcare. It's the violation of the healthcare provider's own policies or the school system's own policies.
Right.
Does it mean it's systemic? That's a tougher thing. Proving intent at a systemic level is a lot tougher.
Yes, definitely. And we know from our past webinar conversations that we've had, just that, as Bill said, that initial person, they are still a patient. If you want to be successful, if you want to have good outcomes, all of that plays into language access. So it is very important whether, we have Title VI, whether we have 1557, whether, whatever is out there, that person is still a patient. They're still a student. They're still a client. So the motivation to provide language access really can indicate the success. So it's definitely something that's important regardless of what's going on in the government landscape, what's going on, in that aspect, to ensure that we are providing language access for success for everyone.
Well, and in fact, several states in the last year have moved to have passed laws to strengthen language access. Connecticut, Colorado, New Jersey, Maryland, and others have, or state court systems like the Ohio state court system have, improved their language access policies or their language access legislation. So it's not just, the Joint Commission. There are also state governments recognizing that they needed to strengthen protections around language and communications access.
Yeah, absolutely. Absolutely. Thank you so much. So, for many inequalities in healthcare, education, and justice systems are structural rather than malicious. Without impact-based enforcement, where do you see the greatest risk of systemic language exclusion going unaddressed?
So this is a perennial question, and I think it's even separate from the enforcement. The enforcement waxes and wanes. It's the federal offices of civil rights have finite budgets, and priorities shift with every administration and every secretary of this, that, and the other thing, and have done so historically. But the structural issues are a real challenge. Part of it is that language access is an unfunded mandate. And so the reason for that is under the theory that operates, as I understand it, for Title VI, is you don't get paid extra to not discriminate. You don't get extra money from the federal government for your program so that you're not discriminating against particular groups. You're just not supposed to discriminate. And so with language assistance, with language access, you can put a price tag on it. Much easier than saying we're not discriminating, the cost of not discriminating based on race or religion or other categories. Similar, there was a backlash to the Americans with Disabilities Act. And I'm old enough to remember this because it required, in a fairly short period of time, very few years from its passage, that publicly accessible places had to have handicap accessibility, had to have parking spaces close in, and the kind of access lanes next to the parking spaces, and ramps and doorways. For someone who's my age, that was a big change because I remember what it was like before then.
Yeah.
For you younger folks out there, you're just so used to the ubiquitous blue handicap sign. There was a huge backlash from all sorts of groups because, retailers were being told, and people who own shopping malls and office buildings were told, they had to modify those buildings to make them accessible. That is now baked in, right? Did the federal government pay for any of that? No, it did not. It did not. The point was you're supposed to do the right thing. You don't get paid for doing the right thing.
Right.
Now, if I want my kids to eat their broccoli, especially when they're younger, did I have to, douse it with melted cheese sometimes? Yeah. Or, you eat, any parent who's ever been has lived through this. Sometimes you have to get them, have to sweeten the pot a little bit. But because language access is an identifiable cost, it gets labeled as an unfunded mandate. And so, okay, it's unfunded. Now you're that hospital administrator, that healthcare system administrator. It's a compliance cost. You're going to seek to minimize that cost. You don't make any profit out of it. And so something that's purchased based on cost can lead to issues of quality, or it can be a budget item that sometimes gets really minimized or eliminated. So that's the first structural issue, is that it costs money to do this. And public entities and public agencies, school systems are always in a budget crunch, forever and always. The second issue is that there's still a lot of ignorance out there. And I used to despair at this. I guess I still do, but it doesn't surprise me anymore that there are language access requirements, right? That what I used to hear going around rural parts of different states, a generation ago, and say, "Oh, those people don't live here." Always those people, right? We
Yeah.
don't have anybody who comes in speaking a foreign language, and I show them the show them the census demographics, show them the surveys we conducted, show them what the frontline people were saying, and say, "Oh yeah, you do, you do." There's still a lot of ignorance out there, and that can be deeply problematic. It's really hard to find a place in America that is monolithically one color, race, ethnicity, language. The country is as diverse as it has ever been. The current administration may try to change that, but it's really not going to be able to. It's going to do a lot of damage, in my view, and I'm on the record elsewhere saying that. But it's not really going to change the fact that you've got multilingual, multicultural populations pretty much everywhere in the country. You really have to look hard to find, places that don't. But there are a lot of places that kind of wake up. Oh, it's a school system out in upstate somewhere that the superintendent wakes up one day and, wait a minute, I've got 40 languages among my 10,000 students, and I only expected one or maybe two. And that's the other pernicious bit too, that people are prepared for Spanish, but they're not prepared for any of the other 800 languages that are spoken in the U.S. and that can show up anywhere at any time. And so that's on the spoken language side. I think on the communications access side, there's also a lot of ignorance about, ASL is just a spoken version of English, that the manual alphabet is fine, that there are all of these other, or that the deaf and hard of hearing are a monolithic group and all have the same kinds of needs for support. And that again is an issue of long-term issue of education, an evergreen issue of education. And I think those are systemic risks that have always been there, might be exacerbated in the current moment, but they've always been there.
Yeah, excellent. Thank you so much. There's definitely a lot of different implications here. And I'm so sorry. And again, I do appreciate your input and your expertise today, Bill. So for the next question, if the Department of Justice will only act on intentional discrimination, does responsibility shift towards courts, states, advocacy coalitions, or voluntary standards? And do those systems currently have the capacity to address these cases? I want to add here that, from our last webinar with Michael Muley, he mentioned that, the Department of Justice has been gutted. I mean, it's running on a skeleton crew. That's the word, not bones, a skeleton crew. So, things like this may be kind of pushed to the back, not even intentionally at this point, but those that are left don't have the resources to be able to pursue all of the things coming in.
Yeah, so I mentioned earlier that if you believe that it's an issue of disparate treatment, of intentional discrimination, you have the individual who believes that they have suffered that discrimination has the right under Title VI to sue in federal court. They need not file a complaint. And it may be the case that that's a better route than filing a complaint and then having it adjudicated as meritless by a biased department of whatever. Which that's or not having it adjudicated at all, having just sit and then and I don't know how that would work if your complaint is still pending, and can the court say, well, you have to wait for the complaint to be resolved? Mm-hmm. It's my understanding, and again, check with your lawyers for actual advice, that if someone believes they've suffered disparate treatment, deliberate discrimination, that they can sue. Are the federal courts up to it? Yeah, they're up to it. They've always been up to it. Does it matter which judge you get? I guess it might. But then you look at, as I said, states, a number of states, and I mentioned 4 or 5. There have been a number of states that have, besides those, that already have language access laws on the books, states and municipalities. The Migration Policy Institute has an excellent report on the current state of play as of early last year, which states and municipalities have their own laws and regulations and policies on language access. In healthcare, it is the standard of care. It is the standard of care under the Joint Commission for Healthcare Accreditation, and it's the standard of care for the organization, I cannot remember the acronym right now, that accredits healthcare plans. So the healthcare plans also have to have language access when you call to check on buying insurance or check on a claim or what have you.
Right.
So that's voluntary standards in the sense that you want to get accreditation so that you can receive federal funding. I mean, it's quote unquote voluntary. There are advocacy coalitions, as I mentioned, the National Coalition for Language Advocacy. There's a number of coalitions in the deaf and hard of hearing world, like DHCAN, the deaf advocacy groups that pay close attention to this. And the courts have generally looked, very much askance at discrimination in any form. It's the Civil Rights Act of 1964, but also prior Civil Rights Acts going back to the 1870s. There's other federal laws that address discrimination. So is it an easy pathway? No, but I think the point isn't so much that we need to be rushing to file cases. It's that the folks who have the most liability are still very much aware that enforcement is a possibility.
Yeah.
And that's just setting aside the fact that we'd like to believe people would do the right thing out of
right.
inherent goodness.
Right. Yeah, I definitely was excited the day that I read about the Joint Commission. And I think that what they did by creating, putting language access under patient safety was an excellent work, an excellent way to ensure that it is still at the forefront of everyone's mind when we're talking about patient care. I really love it. I think that it makes perfect sense to me because outcomes are very directly impacted when language access is not provided. So I really love that they did that.
One of the projects I'm working on with colleagues from Mass General and the University of Maryland and the National Council for Interpreters in Healthcare is a research project where we're analyzing more than that's about 1,500 articles published in the medical literature, so peer-reviewed articles published by medical researchers since 2010, so the last 15 years, with correlations, is some indication of the impact of the provision or the lack of provision of language access on healthcare outcomes, very broadly written. There are occasional articles that will try to summarize this. We're doing some very cool things to be able to include as many of these articles as possible. Some very cool analytic techniques, but our early results are going to be it's going to be unequivocal that the provision of language access and communications access make patients healthier and save hospitals money and make healthcare systems more money than they're putting in. And that's been something we've known intuitively. That's been something that, one-off studies of, say, how do GI surgery outcomes in the upper Midwest compare with language access versus not, things like that, that are very, very limited in scope. And it's just really very clear that providing quality language access, qualified, professional language access as defined under regulation really does make a difference.
And when will that be ready, Bill? Because I'd like to have you back on for a conversation about that one when it's time.
I would say it's probably a year from being ready.
We got a ways to wait.
Yeah.
Okay.
Yeah. I mean,
okay.
it's a huge amount of work that's being done.
Yeah.
A team of
I'm sure.
It's 5 or 6 researchers and a bunch of graduate students working on it right now.
It's very exciting. I'm excited to see those results and learn about all the different ways that language access can impact a patient's experience. I mean, as a former interpreter myself, I definitely can tell you, as I'm sure you have, Bill, that you see it. You see it firsthand when you walk into a room and this patient is like, Okay, I can understand what's going on now. Thank goodness.
Well, I
And
was a technical and conference interpreter. I only ever served as an
oh,
ad hoc medical interpreter when I was living
oh,
overseas, and there were other American expats who needed an interpreter late at night, because
oh, wow.
I would never hold myself out as a legal or a medical interpreter. I don't have the conceptual knowledge. I don't have the terminology I could acquire. I don't know the underlying concepts well
Sure.
enough necessarily. So
Yeah, absolutely.
I
Absolutely.
did things like, NASA conferences and
I mean, that's still important.
astrodynamics articles.
People are still going to be relieved when they can access that awesome information.
Well, the
They've got the
satellite doesn't
interpreter
fall out of the
there.
sky. You know,
Let's hope not.
it didn't. It did. It's still up there.
Oh, thank goodness. Okay, so let's see. Our next question is looking ahead 3 to 5 years. Do you expect language access protections to evolve through civil rights enforcement, through legislation and funding, through the courts, or through market and technology solutions outside of federal enforcement?
Yes.
Tell me more.
Basically, some of all of that I think will happen. Civil rights enforcement, if it comes through the courts, and sometimes through state courts, where state civil rights laws or state language access laws are being availed of. Legislation, I think, will happen mostly at the state level. Although, stay tuned on Friday for which is the anniversary of Lau v. Nichols, for the introduction of the language access bill in Congress. I'm told it will be introduced on Friday. I don't know if it'll pass. It's a
It's hard
long
to
ways,
say.
but
Yeah.
but it serves as a marker, and someday there'll be a different composition of the federal government, and we may see in a different administration or in a different Congress that what we'd really like to see, that language access is explicitly tied to civil rights, for example, and that it's funded. And I think the reason for funding it is less to do with letting people off the hook for not doing the right thing, but more for ensuring that we're getting quality. Because it is an area, as I said earlier, where language access is something you put a price tag on in terms of discrimination. It's also something where you can measure the quality of the access. How good is the language access? Is it being provided? Is it being provided by qualified people? What kind of errors are being made, and so on? And that improving, tying it, in particular in the healthcare and education spaces, putting some funding behind it would really make a difference. Now, that's a long-term goal. We almost got it into the Patient Protection and Affordable Care Act. It was kicked out at the last minute, but when Javier Becerra was a congressman from California, he had it in the House version. Didn't make it through the final version. That's 16 years ago.
Wow.
So yeah, those are longer-term things, and I think the courts. It really depends on what cases are brought. The market. We've already talked a bit about standards, and standards are a reflection of the market. Standards are part of what is used by the market to organize itself. Sometimes the standards are voluntary, sometimes they're quasi-voluntary, sometimes they are imposed by regulation, but the standards are part of what shapes a market, and we're already seeing those standards, as we talked about with the Joint Commission and the release there. As technology, I think that AI, just as machine translation did, machine translation made a lot of content available that was never going to be translated, right? We looked at the release of Language Weaver almost 25 years ago, and I was ATA just after it was released, the American Translators Association. You thought the sky was falling. Everyone's walking around, we're going to be out of our jobs. Computers are going to make us irrelevant. And now we have more translators than ever. AI will change, and it's changing translation and interpreting to some degree right now. It's never going to replace humans, and there are places where it can't. So, for example, the Ohio Supreme Court adopted a rule that said AI and machine translation cannot be used in the courtroom or for anything that is issued by the court, any document that's issued by the court. AI cannot be used for interpreting in the courtroom or in a deposition, anything else that might be part of the court record, status hearings, etc., witness interviews. And machine translation cannot be used without review for anything that might be issued as official paper by the court. However, AI can be used elsewhere in the courtroom. And if you live in small town Ohio, you go into the courthouse to do a whole lot of different things. You might be filing a will or getting a marriage license or looking up a property deed or paying your parking tickets, all things that I have done in courthouses around the country. So were you going to get language access for that? Probably not, because it's a short transaction. It's a short, very transactional. Where do I go to this? How much do I pay, etc. Were you entitled to it? Yeah. I mean, if that state or county court got any money from the federal government, sure. Every single one does, basically.
Right.
Were they ever going to provide it? No, it was completely impractical to do that. You think of an educational setting where I live in a county, Montgomery County, Maryland, with about 160,000 students, more than 200 languages in the school system. So there's no earthly way that every student is going to have a paraprofessional next to them when they come to class. Could AI make that, first, second grade students' experience more accessible? Is it? Yeah, it probably could. Is it high stakes? Not in the moment. In the aggregate over your 13 years of public schooling, of course it's high stakes because, it has a lot to do with what you're going to do with the rest of your life,
Yeah.
but not in that moment necessarily. Would you want it in an IEP meeting or a disciplinary hearing or in the school nurse's office? No, you want professional language services at that point. And so I think that's an area where AI holds the promise of really making more language access available in places where it's not available, was never going to be available, not
Right.
replacing the interpreter in the doctor's office in the courthouse. Now, are there
Right.
doctors who hey, I've got AI, I don't need to wait, 90 seconds for that interpreter to come on the line? Sure. Are they violating their healthcare system's policies? Almost certainly they are. And in fact, I'm not aware of any healthcare system that I know of that has AI interpreting built into the doctor's office right now. The companies that are selling AI interpreting aren't selling it for those purposes.
Right.
And then finally, Safe AI, the Safe AI Task Force, which is just safeaitf.org, has published a lot of material done a lot of research on the state of play with AI and interpreting, along with the Coalition for Sign Language Equity and Technology, and has published ethical guidance for the use of AI in interpreting, as well as a checklist on, for enterprise-sized organizations, if they are looking at AI and interpreting, what do they need to think through in terms of risk management, technological readiness, and oversight and liability, and so on.
Awesome. Yeah. So I definitely see there's potential there with AI specifically to fill in those, as you were saying, those low stakes situations where you just wouldn't have someone there to help anyway. Maybe a cafeteria trying to order some food, trying to ask, do you have vegan options? I do have a question from the audience I wanted to pull in. Speaking about the law that this Friday is the anniversary of. Can you say again, what was the name of the bill?
Sure. The case was Lau, L-A-U, v. Nichols, Lau versus Nichols, U.S. Supreme Court. The bill, I think, is going to be called the Language Access Act of 2026, but I'm not sure of the final title. It should be introduced Friday by Representative Grace Meng of New York. And it covers a lot of ground, including some very clear requirements for technology and making it clear that the failure to provide language access creates an individual right of action. So that kind of vitiates the Executive Order 14224. So we're looking forward to that, and it'll be probably spread pretty widely on ATA, ALC, all the language associations once it is, because I'm asking them to do that.
That's excellent. Good thing we have you there, boots on the ground, to keep us, keep us informed here. I do have another question from the audience. It's from Gabriella Huff. When did the Joint Commission put language access under patient safety? Was that earlier this year or was it December? I don't remember. I just remember being very excited.
Yeah, it was in the last 6-8 weeks. I don't have the exact date in front of me, but it's fairly recent, and I'm pretty sure the National Health Law Program, nhelp.org, published on it, put out something on it. So yes.
Awesome. Thank you. Another question. This is talking about what's happening in the Wisconsin legislature to use AI in the courts. What's your
Yes.
take on that?
So I've been very much involved with this, as has on behalf of the Association of Language Companies, the American Translators Association, the Midwest Interpreter and Translator Association, which is the chapter of the ATA in that part of the country, a number of chapters like the RID chapter, Registry of Interpreters, the Deaf chapter in Wisconsin, ACLU of Wisconsin, a number of state level associations opposing this. And this really comes from a broader push by Republicans in the Wisconsin legislature to do AI everything, everywhere, all the time, as well as some suburban Republican court clerks now. So they're elected. They have like everywhere in America, the clerk of the court is an elected officer, and they're the ones that's responsible for running the court, pushing this law so that AI can be used originally as pretty much anywhere in Wisconsin government, state or local government. There were 3 different bills. One bill passed the state house, and Wisconsin is a purple state. It has a Democratic governor, but a Republican Senate and House that are by a very slim margin Republican. We're not sure it's going to pass the Senate, and we're working very hard in the governor's office to veto it. It is opposed by pretty much everybody: the Judicial Council, the bar, you name it. Nobody wants to see raw AI used in a courtroom. They want human interpreters. Now, for some reason, I've spoken to multiple state Supreme Courts over the last few years about AI and other matters related to court interpreting, and I've said to these judges, for some reason, the worst thing ever is to hold a case over because you can't find an interpreter, can't find a witness. The judge has to go to some kind of continuing legal education conference. Prosecutors on vacation. We lost the evidence, whatever. Those things seem to happen all the time, but can't find an interpreter. Whoa! Can't allow that. We have to, that, and so therefore we need ubiquitous availability of interpreters, or it's too expensive to send an interpreter, say from, the Central Maryland, the Baltimore Washington corridor out to Garrett County, Maryland, 4 hours west of here, and put them up for a week to hear a case. That's just too expensive. Okay, well, you budget for that, and no, it's not. And by the way, the AI is not going to solve your problem with getting a Mapuche or a Zarma or a Karakopak interpreter
Right.
when you need them. Because that AI doesn't work in those languages at all.
Yeah.
Say it works in other languages to some degree, but there's maybe 20 language pairs, maybe 40, depending on who you ask, where it's sort of tolerable. But that leaves another, 7,000 languages where it doesn't work. And any one of those languages could show up in your courtroom at any time.
Yeah, and that's definitely something I think that when looking at trying to apply AI interpretation on a grander scale, people don't realize that Spanish is the most accurate AI that we have. But beyond that, it's still a little iffy with other language pairs, as you're saying, and even more so with those rare language pairs that are going to be, an interpreter coming in from a ways away.
What dialect is Spanish? How much code, how much translanguaging is there? How much Spanglish is there?
Yeah.
Some of my favorite words in Spanglish are like rufero, chingolero, briquero, metalero, right? There aren't, I can't even remember the proper word for a bricklayer in Spanish because no one uses it around here.
Yeah.
If you drive around DC and you go around these big, they're building big apartments up Rockville Pike from us, and it says buscamos briqueros. We're looking for bricklayers.
Yeah.
They don't, and that's just the language as it is, as it exists.
Right.
Unless that's in somebody's data somewhere, and and remember, the large language models, AI ingested the entire internet. There's no more data out there, right? They're creating AI data to train AI on. They are hiring people to create new data, to create new, especially for languages. in
Yep.
order to train AI, and it's a very slow process. So AI is probably, it's about as good as it's going to get. You'll see incremental improvements in AI, but the jump from Chat GPT 2 to 3 was like boom to boom, and then 3 to 4 was and then 4 to 5 is and
Right.
it's just going to, like the background is taking my hand out, but it's like an asymptotic curve in terms of improvement.
Right.
And so, okay, how much error are you willing to allow into your courts? If lawyers are getting disbarred for submitting briefs written with AI that make up citations and misanalyze legal issues, then why do we want to use AI for court interpreting? Now, the counter response, humans make mistakes. Well, sure we do. We also have self-awareness and metacognition and cognition itself. A good interpreter is generally aware of when she makes a mistake and can often repair that mistake within the same sentence before the sentence is
Absolutely.
done. And in fact, the CCHI, the new CCHI English to English test, includes tests of your ability to recognize errors and go repair things, right? That recognizing that's part of, human
Part of the job.
cognition and speech.
Yep.
AI just spits something out. And AI, I don't want to sound like I'm a Luddite because I'm not. But
No,
the
of
other
course
thing
not.
people have to recognize about AI, it is programmed, it is designed to fill in the blank no matter what, and
Yep.
to make one guess.
Yep.
Remember, neural machine translation will offer a range, like a really proper professional neural machine translation engine that you're using in your workflow will offer a range
Right.
of suggestions
Yes.
if it can't resolve the vectors, they say, if it can't come up with the right, a good enough match. AI is going to stick something in no matter what.
Yep. And you're going to not know which part was made up and which part was
Right.
based on fact because it just does
my
it.
favorite sentence in Spanish is "La vacuna no se necesita." Why is that? It's a perfectly good sentence, by the way, perfectly grammatical. The English original, the vaccine is not mandatory. And that was a raw Google machine translate sentence that appeared on the Virginia Department of Health website in 2021 with respect to the COVID vaccine. The vaccine is not mandatory, became la vacuna no se necesita. And that's a change. That is a change in meaning. For any ATA Spanish translation graders, that's, hey, Bill, come back next year, study harder. But the reason it happened is because whoever decided to just run the website through the free Google Translate didn't speak Spanish, and whoever checked it didn't look at the original. So that ended up as a civil rights complaint against 18 state departments of health for using raw Google Translate during COVID. It was resolved, and they agreed to mend their wicked ways and to train their staff better. But it was because of that one sentence that a colleague of mine who teaches translation at a local university had a student and showed me this, and that led to this it's a long story. But the point being that if you don't have access, if you're not bilingual yourself, if you're not a translator or interpreter yourself, how do you know?
Yep. Absolutely. I definitely agree. And it's something that, like, one small alteration, unintentional alteration, can just wreak havoc. Okay, so I do have one other question. We only have a minute. But someone was asking about the decrease in minutes that you mentioned for some language companies that some language companies are reporting. They're asking what industry you're talking about. Is it healthcare? Is it government? Is it legal?
It's what vertical? And hi, Tom. Thanks for the question. We think it's mostly healthcare and education, and we think it's because immigrants are avoiding routine healthcare appointments. Where there's been a scheduled interpreter, they're avoiding routine meetings at the school, and as a result, we are seeing, at least anecdotally, reports of fewer minutes being billed. And this seems to be mostly because immigrants, LEP immigrants, are avoiding the services that they're entitled to, and therefore they're not getting language access at those services because they're not showing up. We'll have more data, I think, coming out the next quarter from a couple of the research organizations that'll give a little more meat to that.
Yeah, absolutely. Well, thank you so much, Bill. That is the end of our time today. I do want to mention, Catherine Lees, I will be typing up the information that you requested and sending it to you after this is all over, so that you have it. Thank you guys so much for your participation. We appreciate your insightful questions and your comments that you brought to the table today. Bill, thank you so much for your expertise. We appreciate your time today and all of the information that you're willing to share with us. And I look forward to future opportunities to coordinate with you.
All right. Well, thank you very much for having me on. And thanks everyone in the audience for coming and listening today.
Guys, this will be on LinkedIn Live, LinkedIn as a recording after the live event is over. So you'll be able to find it there. Thanks, everyone.
Thanks.
Take care.
Bye.